Good. Hello, this is Greg Marquis. Welcome to my paper, Canada's Johnny Reeferseed, the Rowbotham trials, and Canada's post-1970 drug debate. So I am just going to bring up my slides here. Second here. Okay, I think after all these months of doing this for online teaching, it would be quicker. Slideshow. So this paper examines three complex drug trials from the 1970s and 80s and how they fit into and influence the public debate on illegal drugs in post-1970 Canada. It's a modest contribution to the sparse literature, sparse legal and social historiography on the subject. My working hypothesis is that the Rowbotham prosecutions, which focused on the importation of large quantities of hashish, were show trials in Canada's ongoing war on drugs and had significant symbolic meaning for the counterculture. My analysis involves pushing the idea of the counterculture beyond the early 1970s. This research is part of a larger study, a biography of Rosie Rowbotham, from his colorful years at Rothschild College to his arrest in 1974 as a cannabis kingpin, his controversial 1977 sentence, the longest in Canadian history for soft drugs, his second legal battle in the 1980s, which involved two trials and another severe sentence, his work in prison media, cable television show in Kingston, and a magazine for convicts, his stint as a contributor to CBC Radio's flagship program This Morning, and in recent years, his role as an eminence grise of cannabis culture in Canada. This is a story that involves a hippie mafia, bikers, journalists, some of Canada's top defense lawyers, CBC personalities, prison inmates, activists, and academic researchers. I plan to use a storytelling approach focusing on Rowbotham, the so-called counterculture folk hero or hippie drug baron, to explain this era and try to answer the big question: why did it take 49 years after the appointment of the Ledane Commission for marijuana to be partly decriminalized? Normally, the term show trial is reserved for highly staged and predetermined legal spectacles mounted against enemies of totalitarian or authoritarian regimes. In the United States in the 1960s and 70s, it was sometimes used by journalists and activists to describe criminal prosecution for both sides, the forces of the status quo on the one hand, and advocates of political and social change on the other, were attempting to influence public opinion beyond the courtroom. In 1975, Canadian historian Ken McNaught wrote that recent prosecutions of FLQ activists, Black students involved in the Sir George Williams University affair, and labor leaders in Quebec had not taken on attributes of show trials. According to McNaught, who cited examples from the 19th and early 20th centuries, lawyers, judges, the press, and public in Canada, quote, reject any consideration of the courts as positive instruments in the political process. I would like to revisit this debate, or at least start the debate, by adopting a more flexible definition of show trial. By adopting a more flexible definition, I would argue that it is possible to interpret Rowbotham's legal ordeals as putting the counterculture on trial. Rowbotham's story was also part of a Canadian manifestation of the celebrity drug trial, which became a media and cultural phenomenon in the 1960s. The 1969 and 1978 prosecutions of Jimi Hendrix and Keith Richards in Toronto were visiting pop culture celebrities. The 1985 acquittal of New Brunswick Premier Richard Hatfield for simple possession of marijuana involved a Canadian political celebrity. Defendants in high-profile murder cases such as Peter Demeter and Colin Thatcher became celebrities because of intense media coverage and best-selling books. Rosie Rowbotham, Canada's Johnny Reeferseed, and again, that's a term coined by journalist Barbara Emile to describing Rowbotham as sort of an apostle of pot culture in the 1970s. Johnny Reeferseed was a celebrity of sorts in freak culture before his arrest, but he became a celebrity drug defendant in the mid-1970s. And this is well before others such as Mark Emery, so-called Prince of Pot, Chris Clay, and Umberto Iofita emerged on the scene, and Rowbotham paid a much higher price than these individuals for his dedication to cannabis and its consumers. Rosie Rowbotham, who was not a U of T student, began as a small dealer in pot at Rochdale College and soon became a major distributor, not only in the Toronto area, but most of Canada and beyond. His marijuana was supplied from the United States, and the hash originated in war-torn Lebanon. Drug importing and distribution was so lucrative that he laundered his cash by buying and operating a number of legitimate businesses. Brought down by wiretaps, Rowbotham and his associates were charged in 1974 with various offenses, the most serious being conspiracy to import. There was a minimum 7-year sentence for this offense. Police and prosecutors who normally dealt with pot possession and minor trafficking charges finally had a Mr. Big in their sights. And the case was covered early on in quite a lot of detail by the media. For example, a column by Scott Young in 1976 documenting the problems, sympathetically documenting the problems that Rowbotham was having with bail. The defendant's celebrity status was enhanced by 3 things. One was American writer Norman Mailer appearing as a character witness for sentencing. Second was Rosie delivering a rambling but evocative speech in defense of freak culture, and where he told the judge he could not be rehabilitated. And thirdly, the court dealing out an unprecedented harsh sentence of 17 years that drew concern from not only freaks, but also defense lawyers, journalists, and some politicians. That was eventually reduced to a 9-year sentence on appeal by celebrity lawyer, defense lawyer Eddie Greenspan, and Rosie was released on parole in 1981. So here we have Mailer, Norman Mailer, mid-70s. Mailer had already testified. He described the prosecution of Rowbotham as a tragic and disproportionate waste, bad for the cosmos. This got a lot of attention from the media. He had already testified at the trial of the Chicago 7, and as some of you may know, he was involved with the Gary Gilmore story, producing a Pulitzer Prize winning book, The Executioner Song. And also he was involved with the writer convict turned writer Jack Henry Abbott in The Belly of the Beast. So in Maclean's magazine, a feature article, Barbara Emile pondered whether Rowbotham was a sacrificial victim of the clash between the status quo and the counterculture. The victim who was also abandoned by the better educated and more powerful and protected elites who consumed his product. I mean, that's sort of the Barbara Emile treatment, of this. So she was somewhat sympathetic, but also towards Rowbotham, but also mocking him in the counterculture in a way. In 1982, Rowbotham was arrested again, charged with an even bigger conspiracy, this time to import 16 tons of hashish from the Becca Valley. He had been under police surveillance for months. This time there were 11 individuals on trial, including American colleague Richard Stratton, who, if we had time, we could talk about for a long period. Following a lengthy and expensive preliminary inquiry and trial, he was convicted in 1985, Rowbotham, and subjected to harsh criticism from the Crown Attorney and judge, who rejected arguments that soft drugs were harmless. And this was a 20-year sentence, right? The judge, for example, denounced Rowbotham as exhibiting the flower child syndrome. The rhetoric and sentence were possibly exacerbated by growing concerns in this decade about crack cocaine. Rowbotham maintained a lower profile during this trial, but his defiant words from 1977 were used against him. The celebrity factor continued, however, during this trial. This time it was celebrity singer Neil Young, who appeared on behalf of his brother Bob, who was a co-defendant. Neil Young offered typical counterculture defenses of pot and pot users, but his testimony did not appear to help his sibling. And according to one defense lawyer I interviewed, it may have backfired. It was certainly criticized by the Crown Attorney during the sentencing hearing. So in 1977, and again in the 1980s trials, prosecutors, judges, and reporters depicted cannabis users in pro-legalization opinion in nostalgic, patronizing terms. And again, from the point of view of looking at sort of the counterculture and depictions of the counterculture in the 70s and 80s and 90s, this was a really interesting angle. The counterculture, in other words, belonged in the past, not the present, in the future. So it's almost like official Canada was sealing off this period of history. At least one journalist raised the issue of sentencing disparities. Rowbotham's 20-year sentence elicited more criticism from journalists and letters to the editor, including one from poet and pot smoker Susan Musgrave, pictured there on the right, with her soon-to-be partner Stephen Reed, who in 1986 would publish his semi-autobiographical novel Jackrabbit Parole, based on being a member of a bank robber gang. At least one journalist raised the issue of sentencing disparities, a problem that was being examined at the time. So Margaret Gibb Clark has a justice system gone askew in Ontario, pointing out that Michael Waite, a serial impaired driver, had killed, when he was driving while impaired, had killed 4 teenagers and received a sentence of less than 2 years, where Rowbotham, for trying to import 16 tons of hashish, had received a 20-year sentence. Of course, that was an issue that it was being looked at that time, the Canadian Sentencing Commission, for example. So getting back to our timeline, as he worked in prison on his BA from Queen's University, Rosie appealed the conviction, and the Ontario Court of Appeal agreed that the trial had been irregular. His new trial, however, produced another guilty verdict, slightly less harsh rhetoric from the judge, but another long sentence, this time of 17 years, which was reduced to 13 eventually. This appeal also produced a ruling of constitutional significance that allowed defendants to make a special application for legal aid. So if you go to law school, you will study the so-called Rowbotham application. So the sentence was reduced to 13 eventually, but in the meantime, an unrepentant Rowbotham had become involved in yet another importation scheme. In this case, it was marijuana from Texas, a relatively small amount, and he was finally charged in 1991. 2 trials later, he was convicted and sentenced to another long sentence. So it's interesting that Rowbotham and his colleagues were involved with many of the leading defense lawyers of the day. We mentioned Andy Greenspan, Clayton Ruby, Alan Gold, and others we could mention. So in 1994, he was convicted of that Texas plot and sentenced to 18 years. And interesting, the sentence was to begin in 2002. So do the math on that one. So in addition to scouring, interviewing Rowbotham and scouring newspapers and magazine articles, tracking down court transcripts and studying appeal court decisions. And just to back up on the court transcripts, many of us are in this position, but it's been very difficult during COVID with archives closed or on reduced services to track down primary documents, particularly when you can't travel to the province, right? So right now, the Archives of Ontario, from what I understand, is only processing things that are needed for legal reasons and, quote, humanitarian reasons. So I've made a request for the transcript for the first trial in the 1980s, which is probably going to be huge. And the only reason, one of the reasons I could track it down is that because it went to the Court of Appeal. So when something goes to the Court of Appeal, then the Court of Appeal gets the transcript and the documents from the trial, right? So I'm waiting to hear back on that one. So these are some of the sources I've been working with. I've also been interviewing academics and lawyers who were on the front lines of the war on drugs or drug issues in the 1970s, 80s, and 90s. One is law professor, lawyer, and journalist Alan Young, who was involved in a minor way in one of Rowbotham's cases. As you may know, Young is a believer in decriminalization of cannabis, and he claims in his 2003 book, Justice Denied, to have been motivated to fight injustice in part by the heavy-handed treatment of Rowbotham and his colleagues. He's also confirmed this in a recent interview. Young, in 1994, successfully fought the 1987 Criminal Code section against so-called drug literature, which was targeted against High Times and publications advocating marijuana use and head shops and things like that. I think this just was an Ontario case, but the Crown chose not to fight it, and that sort of nullified that private members bill of 1987, which made it illegal to sell and promote so-called drug literature. 1997, he was involved less successfully in R versus Clay. This centered on the sale of hemp products and marijuana seedlings in Ontario. There's Chris Clay on the right there. and this was kind of a cause célèbre of the 90s. Expert witnesses testified at this trial. They were hoping to use the charter to strike down part of the Narcotics Control Act. In 2003, the Supreme Court of Canada upheld the Ontario Court of Appeal ruling that Chris Clay's charter rights had not been abridged, and so that challenge was not as successful as the drug literature challenge. Defense lawyer and civil liberties activist Clayton Ruby, who I also interviewed briefly, an early advocate of decriminalization, sees the prosecutions of Rowbotham as being about more than simply, enforcing the law in a specific case. He sees them as having a part of a broader agenda and broader significance. They were important battles against the legalization movement. And so again, this gets us into the issue of what is a show trial, right, and what is not. It's interesting about Mr. Ruby raised another issue that presents difficulties for historical researchers working in legal issues, and that is solicitor-client privilege. As he said, there's a lot of things he'd like to tell me, but he was about this in other cases, because I think the week I spoke to him, I mentioned that we had actually found traces of him in 2 of my courses in 1 week. And again, solicitor-client privilege, as long as your former client is alive, you can't really get into the legal details, right? So anyway, so the interesting thing about Ruby as well is that I found out he was defense counsel in Toronto drug courts in the 1970s, right? The same courts that were studied for Patricia Erickson's book, Cannabis Criminals, which appeared in 1980. Classic study. So here's an interesting comment from Rosie Rowbotham. Of course, once marijuana is decriminalized in Canada, he is interviewed a lot, Manchester Guardian, Canadian Vice, and other publications. To be honest, I've never considered myself to be a marijuana activist. I wasn't a campaigner for legalization. I was making big money, and legalization would have been bad for business. Now, despite this self-effacing comment, Rowbotham is aware of his place in Canada's legal history. I have been interviewing him. And since the decriminalization of marijuana, he has made 2 important points. They're not original, but I think they're worth reminding ourselves of. One is the human cost of the war on drugs in terms of tens of thousands of Canadians saddled with criminal records, 600,000 by 1998 alone. So if you go back to his drug influence speech in 1977 in court, he was identifying those issues, right? Secondly, the hypocrisy of former police officials such as Julian Fantino joining corporate boards and seeking to profit from the cultivation and sale of legal marijuana. Rowbotham has pointed out that they really want to have, able business people running this industry. Why not put some of the former hippie mafia who ran successful businesses back in the 70s in these positions. So the final thoughts, one of the things about this issue, this project, it does bring back the issue of the difference between the counterculture and the new left, something I've struggled with in teaching a course on 1960s Canada and also writing about the period. A lot of the classic confrontations that we teach about and maybe research and students are interested in are sort of new left, organizations, anti-war, Quebec separatists, labor confrontations, LGBT rights, and things like that. It's the student movement, right? And so, it does raise the question: what is the difference between the counterculture and the new left, and then what should we look at in terms of legal history? Who were the social rebels in the era? Obviously, new left is resisting the state, but so is the counterculture, but perhaps in a less organized way. So I found this kind of amusing too. There's a fellow who's sort of putting out these illustrated books on sort of the history of cannabis and the struggle for decriminalization in Canada. So this is something that I'll have to put on my reading list. So some of the limitations and challenges of the study. One is, I mentioned the limitation of doing oral history with lawyers, solicitor-client privilege. Secondly, acquiring the transcripts, first of the court cases, tracking them down and also paying for them. because they can be quite lengthy and expensive. And the third one is, I guess, danger of exaggerating the significance, of the subject, the visibility of Rowbotham, the impact of the trial. This is something I'm going to have to struggle with. I did interview one leading drug policy researcher from the period who was located in Toronto, worked for the Addiction Research Foundation, attended all the policy meetings and appeared, in trials and made appearances before Senate committees and things like that. And this person had no specific memory of Rosie Rowbotham. So when I heard that, small alarm bells started to go off in the corner of my mind. Anyway, that's it. This is sort of the beginning of a bigger project, and I'm looking forward to hearing from people, the discussion, and also the conference in general. I'm grateful to be able to present to you. Thank you.